On behalf of the Law Society, I welcome you all here. It's great to see so many people up so early. We thank our partners 2610 and the Faculty of Law for hosting this event. Today is entitled Right for the People, the Law in Plain English. The law and plain English have often not got along very well. Frequently in practice, I've seen letters and documents that I can't understand, so I worry for the poor client, and I cringe at some of the documents that have come out of my office. The Society believes plain English is an access to justice issue. People cannot fully participate if they aren't able to understand what is being written to them by lawyers, courts and government agencies like Centrelink. If they can't understand, it can often lead to injustice. Today we have a number of speakers. The first is Anita Planchon. She's the Manager of Literary Services at LINC, the Tasmanian Department of Education, with responsibility for 2610. Please welcome Anita.
Thanks, Rohan. And I'm actually not so much of a speaker as playing the role of MC today. So before we start, I'd just like to let everybody know that this event is being filmed and photographed. If you don't want to be filmed, put yourself behind a pillar somewhere. But do just let us know and we'll make sure that we respect that. And I'd also like to ask you to put your mobile phones on silent now, please, if you haven't already done so. But do feel free to tweet at 2610law if you feel so inclined. I'd like to acknowledge the traditional and original owners and custodians of the land on which we meet today, the Rowena people, and pay my respects to their elders, past and present. We've had an amazing response to our invitation to today's event, and it shows the very strong interest in this issue and in hearing from our panellists. 2610, for those of you who are not aware, refers to the 26 letters of the alphabet that we use for reading and writing and the 10 digits we use for counting. We call them the tools for life. It's Tasmania's response to the challenge of low adult literacy. It's a network of organisations, communities and individuals who contribute in many different ways to raising awareness, helping people improve their skills and promoting the value of communicating clearly. 2610 exists because the OECD's International Survey of Adult Competencies in 2011 found that almost 1 in 2 Tasmanian adults did not have the level of literacy considered necessary to function in life and work in the modern, technologically rich world. Those stats are slightly worse in Tasmania because of our demographic and regional skew, as they often are. But this is in fact a problem that's found across Australia and in fact across the developed world. There are many reasons for it: childhood illness, poverty, learning difficulties, disruptions to education, and the stigma, which means that people are reluctant to talk about their problem and to come forward and seek help. But it's not a situation that we want to tolerate in Tasmania. It's not tolerable that so many people in our state have difficulty filling out forms, reading a bus timetable, and understanding labels on a medicine bottle, let alone understanding the law. So 2610 is providing direct support to people through the LINC Tasmania Literacy Service, through grants to employers and communities, and through the activities of our network, which now has more than 600 member organisations and individual supporters, and that's about a 3-fold increase on this time last year when some of you might have been at a panel around plain English. So it's a growing momentum. And we're engaged through the 2610 Coalition with specific industry sectors. And to make communication easier for those with low literacy, throughout this work, we advocate the use of plain English. Plain language, termed by the Plain Language Federation as communication in which the wording, structure and design are so clear that the intended audience can readily find what they need, understand what they find and use that information. And we're particularly pleased to be working closely with the legal sector under the guidance of our coalition member, 2610 coalition member for the legal sector, Tim Tierney, to promote the importance of this. For people with low literacy, the law, even simple areas like a rental contract, can be particularly challenging and confronting. And unnecessarily complex language makes it even more so. The legal sector has been at the forefront of the plain language movement internationally and in Australia. And in Tasmania, the legal sector's engagement with 2610 has been fantastically enthusiastic. Most recently, 2610 has been working with the Faculty of Law to embed plain English in their courses, and with the Law Society of Tasmania to offer legal practitioners a chance to brush up on their plain English skills and improve their knowledge of the impact of low literacy. And of course, we're very delighted to partner with the Law Society of Tasmania and the University of Tasmania's Law Faculty today to focus on plain English and the law in this panel discussion. So let's move to our panellists, who I'm sure you're all waiting to hear from, and I will introduce them and ask them to speak for 10 minutes each, and then we will have questions and discussion, and we hope to finish at 9:15. So our first speaker this morning is Hamish Locke. Hamish is State and Legal Practice Manager of the newly established Tasmanian Aboriginal Community Legal Service, which was set up in 2015 with offices in Hobart and in Launceston. Prior to working for this service, Hamish was a lawyer and then managing lawyer with Victoria Legal Aid, specialising in crime and family violence, and before that with the Tenant Union of Victoria and the Hobart Community Legal Service. Thank you, Hamish.
And thank you, Anita, and good morning, everybody. As Anita suggested or said, I'm speaking today about plain language and plain speaking in the law. Using the right language when speaking to our clients. In my case, the context of providing government-funded legal services such as legal aid and community legal services. The majority of people who use these services come from situations of social disadvantage, with low literacy skills, sometimes mental health issues, or English as a second language. These services exist so that everybody in our society can have access to the justice system. Legal rights and the right to legal assistance are highly valued in our society, and for good reason, as the law can have a significant impact on people's lives, such as where someone lives, who they can associate with, where they can go, and in dire situations, whether or not they go to jail. However, these rights and the obligations that flow from them will have really little value if they are not explained to people in a way that makes sense to them. Technical legal language can be alienating. Some people will switch off when they hear it. For some, it can contribute to institutionalisation. When I first started practice at the Hobart Community Legal Service, I had a client who I was assisting with a Centrelink debt matter. I recall only ever speaking to her over the phone. I don't recall ever meeting her in person. I'm pretty sure that I didn't. When I first spoke to her, she was insistent that I was taking her money, that we were taking her money. I went to, what I thought was quite some detail as to, no, we're not Centrelink, I'm your lawyer, I'm here to help you with the debt. I ultimately was able to convince Centrelink to cancel the debt and repay the amount of money that she'd already paid. I called her back that very day, very excited. She probably hadn't received my carefully crafted legal letter yet. And I informed her that we'd been successful. She wasn't nearly as excited as I was. In fact, she was exactly the same as when I'd spoken to her before. She said, "Then why are you lot still taking my money? I want my money, stop taking my money." I realised that she hadn't understood my role at all. All the letters, the phone calls to update her on the progress of her matter, I just hadn't gotten through it all. For her, I was just another part of the institutional world that she lived in. I was effectively the same as Centrelink. Plain speaking is about communicating with your audience in the most appropriate way to make sure that you are properly and completely understood. It's, in my view, part of good advocacy as a lawyer to pitch your point to your audience so that they understand you and you use as few complex words as possible. A lawyer in a community legal centre or a legal aid commission learns to speak in a variety of different ways, can go from talking to a client to negotiating with prosecution or another lawyer, and then into court to appear before a judge or a magistrate. Each of these interactions will require a different style of language, just the way you might speak to your friends at the pub, perhaps in the locker room, and then use a different mode of language when speaking to your grandmother at Sunday dinner. The language of legal education, of course, has been alluded to already, is very academic. Students go through university learning to speak in academic terms and pick up a lot of legalese along the way. In my experience, toward the end of law school, efforts are made to try and break down some of these academic languages, some of the words spoken and written, so that young lawyers are prepared when they enter the legal workforce to have to talk to real people about real issues. I've seen plain English and the movement toward plain English criticised in some circles. Some claim that it devalues or reduces language in some form to its lowest common denominator. And it may surprise some of you to hear that lawyers can be a bit vain and a bit self-important and a bit precious about things like language. I know I certainly was when I first encountered plain language. You can't use the word shall. Shall's fundamental. You have to have the word shall. But plain English, it's not dumbing down of language. It means carefully considering the words you use and selecting the terminology appropriate to your audience to maximise the chances that you're going to be understood. It doesn't oversimplify or make language clumsy or imprecise. It does the opposite. It's cutting to the chase, getting down to the basics of what someone's legal rights or responsibilities are, and importantly, the consequences that can flow from the decisions of a judge or a magistrate. It doesn't threaten the integrity of the use of legal language. There'll always be a place for legal language between academics, between lawyers and the bench, between lawyers and other lawyers. It does take a skill to use plain language to adapt speech patterns to suit the appropriate audience. It's very easy to slip into technical legal language when you're in the flow of describing something or explaining rights and obligations to a client. However, the way a criminal lawyer will talk to a client in police custody when using plain language will be very different from the way a lawyer might talk to the magistrate, of course, and how they might talk to a client who walks into their office. Some of the techniques I've used in plain speaking are as follows. Speaking slowly and clearly. I'm trying to do that right now. This is particularly relevant when speaking to someone from a non-English speaking background. Avoiding complex legal terms and concepts. It can be difficult in a legal context not to use legal terms because we as lawyers use them all the time. However, a lot of people won't be familiar with terms like remand, adjourn, warrant, mitigation, habeas corpus. Getting to the point and being specific is also vital. Saying things how they are, rather than using legal expressions such as sentencing tariffs, maximum penalties. It's often a lot more valuable to cut straight down to it and say, mate, you're facing a jail term. It's a lot more effective at getting to the heart of the matter, what your client really needs to know. And it's a lot more effective than using formal legal language. One should also observe body language and responses. People with intellectual disabilities, for example, are very good at hiding the fact that they have an intellectual disability and often have a stock of phrases that they use to hide the fact that they have this disability so that they're not judged negatively by the people they encounter on a day-to-day basis. People with low literacy skills can be too embarrassed to let on that they don't know what you're talking about, and they'll simply nod and say yes. They'll wear that glazed-over look that I often get when someone talks to me about accounting. Having clients repeat things back to you to ensure that they've understood you is part of this. Part of this is not asking questions of clients that have a yes or no answer. It's easy for someone who doesn't understand you to simply nod and say yes when you've said, do you understand? The primary role of a lawyer is to communicate with and advise their clients. This means explaining legal issues and challenges in a language your client can understand. Attending court is possibly the most daunting and frightening experience most people can have, even for the most literate of people. It's an experience that can be filled with uncertainty and the gravitas of the court environment. Wigs, gowns, police officers, court staff wearing funny uniforms. All of this can add up to making people nervous, particularly those appearing before a judge or a magistrate. Often, taking instructions and giving advice can occur in court interview rooms and court foyers or in police cells. Adrenaline, stress and anxiety will run really high in these settings, so it's vital that a lawyer's advice is clear enough to cut through the stress and the anxiety our clients naturally feel in these environments. An example, and I think a very important one, assisting alleged perpetrators of family violence on bail applications or family violence applications. This requires very careful and pointed use of language, of plain language. A lawyer needs to make sure that the client understands every step of the procedure. People accused of these offences are often brought in by police after hours intoxicated. They'll spend hours in police custody before being brought into a police cell and then before a magistrate. A lawyer representing someone in this situation needs to advise them very clearly and without mincing words exactly what they've been brought in for, the community's attitude toward their alleged behaviour, and the consequences of breaching any bail condition or clause in a family violence order because, as I like to say to clients in this situation, as sure as the sun will rise tomorrow, if you breach any of these clauses or any of these bail conditions, we will be having this same conversation back in this police cell, but you probably won't be going anywhere afterwards. In this way, your client is protected from themselves. The alleged victim and family are protected from your client, and the community is spared the expense of further police and court action. Plain speaking in the legal profession, certainly in mine, is about being real. It's about explaining to clients the realities of their situation and making sure they understand all of their rights and responsibilities, often speaking in broad colloquialisms. There's a reason a person seeks a lawyer's advice, and it's incumbent upon legal professionals to make sure that advice is understood. Certainly, for our clients, the consequences of not understanding our advice is detrimental to them, in many cases significantly, and the flow-on effects can be detrimental, often significantly to others and to society in general. Thank you.
Thank you, Hamish. I'd now like to introduce Rowena Holder, who is President of the Guardianship and Administration Board. She's held this role since August 2016 and was formerly a member of the board for 6 years prior to that. Rowena has also been a legal member of the Mental Health Tribunal since February 2014 and was a manager of advice and legal services at the Legal Aid Commission of Tasmania and a litigation solicitor in Launceston for 14 years, working initially in the area of crime and then in civil and family law. Rowena is an accredited mediator and a trained family dispute resolution practitioner. Thank you, Rowena.
Thank you very much for the invitation to speak today. Under international human rights law, as well as the right to equal opportunity, we all have the right to participate in our community, to have equality before the law and freedom of expression and belief. Access to justice, access to services, access to information is therefore fundamental to a fair and inclusive society and a central tenet in addressing disadvantage and inequality. Human rights treaties apply to everyone in our society. Now, interestingly enough, evidence exists that people with disabilities, and approximately 10% of the world's population has a disability, encounter even a greater range of social obstacles which prevent them from, amongst other things, enjoying equality and from accessing justice, information and services. The United Nations Convention on the Rights of Persons with Disabilities, which was ratified by Australia on the 17th July 2008, addressed these issues. Now, the purpose of that convention is to promote, protect and ensure the full and equal opportunity and enjoyment of all human rights and fundamental freedoms for all people with disability, and to promote respect for their inherent dignity. Now, I raise this convention, obviously it's very important to the work of the Guardianship and Administration Board, but I also highlight it because a number of the articles is really based around accessibility. Article 9 provides for accessibility, that people with disabilities have the right to access all aspects of society on an equal basis with others, and that includes the physical environment, information and communication and other facilities and services provided to the public. Article 13, access to justice, provides that people with disabilities have the right to access justice on an equal basis with others. Article 21 provides for the freedom of expression and opinion and access to information. So central to these human rights is the ability to be able to access information. And so from that it follows it is necessary for a person to be able to understand information that is provided and then obviously be given an opportunity to respond to that information. In the legal arena, it is arguable that where the law is easily incomprehensible or only accessible to expert lawyers, it is arguable it's not compliant with basic human rights. Many law themselves and many legal and court processes are antithetical to these basic human rights. Some of our laws are expressed in arcane language. Some of our procedures are very formal and foreign to lay participants. And court processes can be inherently stressful and confusing and may preclude meaningful participation. And even matters that never come before the court, which we encounter in everyday life, but still have a legal nature, such as contracts for mobile phones or internet usage agreements, rental agreements, loans and finance agreements, and for some of us, parking fines. This can cause significant confusion and difficulty. Can you stop and imagine that if you can't read or you have low literacy and numeracy skills, how truly challenging these documents can be? So for those with communication difficulties, our laws, our legal processes and procedures can be just sometimes too difficult to navigate. Similarly, for those who have communication needs, participation in many social processes is virtually impossible. And by way of example, let us take the work of the Tasmanian Law Reform Institute, who call for submissions on many important law reform issues of general interest and concern to the public, such as human rights laws. I'm advised that the Guardianship and Administration Act will be subject to review sometime later this year. But if materials distributed cannot be read and understood, then obviously that precludes participation at all levels. So why is this issue of clear communication and accessibility so important? Because in the absence of such clear communication, there are serious impediments for people to have their voice heard, to exercise their rights, their basic human rights, to challenge discrimination and to hold decision makers accountable. There are impediments to accessing services and impediments to participating fully in our community. So what can be done to overcome these impediments? And firstly, just the recognition that we're here today, that this is a serious issue which requires a collaborative response by government agencies, by the legal profession, by law courts and tribunals, businesses and community, to ensure that communication is accessible and clear to all units. Obviously, having communication assistance and gateways to assistance is of critical importance. Now, obviously, those who can afford it can access legal communicators by way of lawyers. But what about those without the financial means? So therefore, it's imperative to ensure that the legal aid commissions and community legal centres, Aboriginal legal services, are resourced sufficiently to provide legal literacy and legal advice to those who need it, and particularly to those who are vulnerable or are disadvantaged members of our society. Having court networks to provide personal support, non-legal information and referral to those in contact with justice systems, like Court Network in Victoria and Court Network in Queensland, who recognise that there are significant barriers to accessing the justice system. And so they, manned by many volunteers, provide support and information about going to court. They help explain to people the decisions that affect them. They use plain English in their documentation and in their one-on-one explanation. And they provide referrals and advice on other support services that may be available. They facilitate access to interpreters, and they also even sit in court, show them around the court beforehand, and provide significant support. Obviously, we need to canvass and encourage the use of government agencies and businesses in communities to use plain English documentation, to use pictorial aids, use video and audio presentations, attend plain English workshops and access plain English resources online. I mentioned before the Tasmanian Law Reform Institute, and I note in contrast on the Australian Law Reform Commission's website there is information available in easy English, an accessible format that uses simple everyday language and illustrations, and this easy English version is available in 21 different community languages, including Auslan, and also uses pictorial and audio aids. And there are obviously many other strategies which I haven't mentioned today which can be utilised to promote clear communication. Lastly, the focus on the work of the Guardianship Administration Board. As you know, it's an independent statutory tribunal. Our major function is to protect people with disabilities and to appoint guardians and administrators as substitute decision makers for people who have a disability and because of that disability are incapable of making their own decisions. So what do we do to in the form of using plain English? Well, members and staff receive training in respect of communicating effectively with users of the board. Obviously, we are able to conduct our hearings in an informal way, an inquisitorial style, primarily to facilitate the meaningful inclusion of people with disabilities. We regularly refer and answer inquiries at the registry as to process and procedure. We encourage people to contact advocates and legal services. We have a video on our website demonstrating the board's procedures called Are You Attending a Hearing? And the board has completed the process of converting some of its web-based fact sheets to easy-read English to enable people with disabilities to be better informed about guardianship and administration laws. And this certainly represents our commitment to upholding Article 9 of the United Nations Convention on the Rights of Persons with Disabilities, which states to promote the design, development, production and distribution of accessible information. Also, where a person who is the subject of the hearing does not have legal representation, has no informal supports by way of family or services, has no advocacy support, extreme care is taken to ensure communication is very clear and that our process is being understood. When reasons for decision are sometimes asked for, we have decoded our reasons and provided them in easy-read English. We take very seriously that plain English and clear communication is a basic human right. It is central to ensuring equality and opportunity for all. Thank you.
Thank you, Rowena. And now I'd like to introduce a man who doesn't really need an introduction. We're very, very pleased to have here today and to have the opportunity to welcome the Honourable Michael Kirby, AC, CMG, renowned international jurist, educator and former judge. He's obviously held many eminent roles in the law and in education in Australia and overseas. And I'd just like to point one out, just one, that isn't in any of the CVs and things, but is particularly of interest today, and that's his role as patron of Clarity, which is the international organisation that advocates the use of plain language. Thank you, Michael.
Thank you for having me here this morning. I acknowledge the presence of Chief Justice Alan Blow, who's always faithful and comes to support activities of this kind and is a good friend and a long friend of mine. I acknowledge the presence also of Rowena Holder, and I congratulate her on her appointment to her office. And I like very much the fact that she began her talk with references to the norms of international human rights law. It's natural that in a guardianship tribunal you will do that because of the role in the work of that tribunal of the International Convention on the Rights of the Disabled. But it is helpful, I think, for other lawyers and other office holders to do so, because often the international instruments express things in simple and conceptual terms, which is not the feature of the English legal tradition, which is the tradition we have inherited. The English legal tradition tends to be very detailed, and that had a purpose. Its purpose was that Parliament would not interfere with people except by very express and clear and detailed provision. And unfortunately, the detail often meant the provisions were not so clear. But the tradition of the Universal Declaration of Human Rights of Eleanor Roosevelt and the tradition of the international instruments is often to try to conceptualise the principle and to state it, and that makes it understandable, including for lawyers and ordinary citizens. And I acknowledge the presence also of Foon, President of the Law Society, showing the support of the Law Society for this enterprise. Actually, I was in Melbourne last night for the 50th anniversary celebration of La Trobe University and the 25th anniversary of their law school. So I came down to Melbourne for that purpose, and I got it seemed like the 5 a.m. flight of Jetstar to Hobart this morning. Basically, I'm here at the expense of the University of Tasmania, whose Dean, Margaret Otlowski, is here. And if you don't like what I have to say, well, I don't care, because I got up very early to say it, and it's not costing you anything. Therefore, you've just got to sit there and put up with it, okay? I became involved in plain. Often when you go to conferences now, they don't talk about plain English, because this is a global phenomenon, and it affects German and French and Chinese and all the other languages. And sometimes it's called the plain language movement, and sometimes it's just called plain. But the purpose of it is to help us all to express things in clearer terms. And the objectives of 2610 are objectives that are addressed to the very particular needs of people who find it difficult to understand legal texts. And that isn't necessarily people with disabilities. It's the fact that lawyers sometimes speak an utterly different language. Justice Alan Wilson gave a very good paper. He's a judge of the Supreme Court of Queensland, and he gave a very good paper recently contrasting the way lawyers tend to say things and the way ordinary folks do. He said the legal way of saying what would be said ordinarily as "help yourself to an orange" was, "I, Alan Wilson, give you all and singular my estate and interest, right, title, claim and advantage of, and in this orange, with all its rind, skin, juice, pulp, and pips, and all rights and advantages therein, and full power to bite, cut, suck, and otherwise eat the same, or give the same away as fully and effectually as I, the said Alan Wilson, am now entitled to bite, cut, suck, or otherwise eat the said orange, or give it away, etc., etc. The clause goes on for another half a page, and that was the way in which a lawyer set to work to draft a provision that said, help yourself to an orange. And he also quoted a provision which is a standard provision in a lease, which is dealing with the fact that the tenant had to keep the premises in good repair. The tenant shall, when, where, and so often as occasion requires, well and sufficiently repair, renew, rebuild, uphold, support, sustain and maintain, pave, purge, scour, cleanse, glaze, empty, amend, and keep the premises and every part thereof, and all floors, walls, columns, roofs, canopies, lifts and escalators, shafts, stairways, fences, pavements, forecourts, drains, sewers, ducts, flues, conduit. Well, I won't go on, but you get my drift. And this is the way somebody drafted it. Somebody said, oh, that doesn't include, and then they added something. Somebody drafted another thing, something else was excluded, and so a clause of that enormity emerges at the end of the process. And there is the added 21st century factor. It then goes into a computer, and it is regurgitated unquestioningly, and then we're all stuck with it. And so this is not just a problem for people with disabilities, this is a problem for all people, including lawyers. Actually, Justice Wilson makes a point which I'd never heard of or thought of. He said the English language, in the Anglo-Saxon form of it originally, loved alliteration. And the reason for that was that in a pre-written culture, when people didn't write things, alliteration helped people to remember things. And therefore, if you had alliteration, you could sort of run it over and you liked the sound of it, and that became something which you did. And then things were complicated even more when William the Conqueror made his long visit to England and came over with his clerks, because when that happened, the English language was changed overnight. 1066, over came the French-speaking clerks. And accordingly, what we have in the English language, and many of us don't realise this, is basically a duality of a language. We have a basic Anglo-Saxon Germanic language, and we have a basic Franco-Latin language of the written clerks. And we tend to write differently than we talk. And our writing has the formality of the French language. And we use the French language, we slip into them naturally. And the language we speak in the kitchen is a Germanic language. It's why it's easier for us as English speakers to speak German than it is to speak French. And yet it's easier for us to read French than it is to speak German with the way they run words together. Verfassungsgerichtshof, which is the highest court in Germany, and it's all one word. They put all the words together. Or Anführungszeichen unten, which is inverted commas under the line, which is the way they have the inverted commas. It's all joined together. German is hard to read, but it's easier for us to speak because our spoken language is a Germanic language. And so we've got a mixed up language. Sorry to tell you this, I hope it doesn't spoil your breakfast or your day. It's wonderful for poetry. It's wonderful for literature. We've always got two words for every idea. Last will, the German word, and testament, the French word. So we've always got two words. And if we put them all in, that they'll have nuances sometimes of difference. That leads to confusion, ambiguity, and a lot of money for lawyers. But it leads to an impenetrability for many people, including some lawyers. So the problem I've found over the last 30 years that I've been involved in this, since I got involved in the Law Reform Commission, is that a lot of lawyers are very hostile to plain. I'm sorry to say this. A lot of my judicial colleagues have been very hostile. When Parliament has tried to express things in plain, they attack it. Justice Roddy Marr, my dear friend on the Court of Appeal of New South Wales, who was a very clever man, a very great writer and a good judge, he hated plain English. He didn't like it. And he set about every time there was an attempt in a statute to express things in plain, he set about to try and carve it up and show how it had failed. It was a failed idea, and it was trying to replace well-honed, well-understood words, and he was again it. And I'm afraid he wasn't alone. And there are people in the law who just say, well, that's just ignorant, and those people don't know what they're doing, and they're mucking up well-settled phrases. Well, sometimes well-settled phrases have to be modified in order to get to a plain and easier understood expression. Chief Justice Mason did me the greatest compliment, and he's a very, very great judge of Australia. I think one of the greatest, if not the greatest Chief Justice we've ever had. He said on the High Court and earlier in the Court of Appeal, if you want to know what the case is really about, you read the Kirby judgment. And you've then got to go and read the others because he might have dissented. But some people can express themselves more clearly, and I think it's because I just write. I don't know why it's easier to understand, but I think it, and students tell me it's easier to understand, but I think it's because I write more as I speak, and I think I'm writing in the Germanic language, and that is something which is easier for us all to understand. So keep that in mind in dealing with the problem which is before us this morning. Now, this is quite a complicated thing. It's a big study internationally. There are lots of experts. There are whole journals about plain. There are books about it. And, you know, some people spend their whole lives dealing with this issue. But we don't have time for that. We've got to get back to work and we've got to get on with it. And therefore, what I've attempted to do is to express 10 commandments, which are very, very simple rules. If only we could teach these 10, it won't give everybody the whole of the plain movement, but it'll give them the guts of it. And guts is definitely a Germanic word. It's not, the French would never use such a short and pithy word. So here are my 10, and you might have a different 10, but these are my 10. Number 1 is begin with a short summary. If you're dealing with a complicated issue, begin with a short summary of where you're going to go on your journey and where you're going to end up. And good judges tend to do this at the beginning of their opinions by setting out the nature of the case, the nature of the central issue, and how that is resolved. And so you know at the beginning, and you can read everything that follows in the light of understanding where on earth you're going with this exercise. So that's the first thing. The second thing is short sentences. there are some passages in the Australian Communist Party against the Commonwealth, which is one of the greatest decisions of the High Court of Australia. It was a decision that struck down the Communist Party Dissolution Act and said that you can punish communists for what they do, but you can't punish them for being communists. That decision, striking it down, the principal reasons were given by Chief Justice Dickson, a very great lawyer and judge. But if you look at it, it's 1951 Commonwealth Law Reports, if you look at it, there are passages which are 300 or 400 words long without a single full stop or semicolon or anything in the middle of it. It's just too long. And the mind begins to wander after about 40 words. So I'm not criticising Chief Justice Dickson because the issues are often complicated, but splitting it up with full stops is a very good way to make things clearer. And great legal writers like Lord Denning always use lots of full stops. It's the language of clarity to make things clearer. Some people use semicolons, others say semicolon is a relic of the past and you should just put a full stop. Young people don't know what a semicolon is. They don't know what grammar is and they don't know what spelling is. But full stops, okay, that's the second rule. Third, avoid the passive voice and use the active voice, such as John Smith drove the car. The car was driven by John Smith. That's the passive form. Sometimes you might want to use the passive voice. I'm not saying it doesn't have a role, it's part of our language. But the advantage in legal writing is in using the active voice is that it tends to reveal the duty bearer. If you put the active voice and state there should be a law against this, or the law is against this, it says, or the president of the Guardianship Tribunal must. If you indicate the duty bearer at the beginning, it's much clearer than if you say there is a provision in the Guardianship Act that provides and so on, and you don't identify at the beginning by the active voice the duty bearer. Number 4, be careful of adjectives and adverbs. They're lovely in literature and novels, but they do tend to modify and qualify the words, and they take away from the clarity. Words of emphasis go at the end of the sentence. Words of connection go at the beginning of the sentence. Number 5, prefer the shorter word, the Germanic root, to the longer word, the French root. And there are many examples of that where you're using an expression which the French word will tend to be longer and less comfortable. Looking at the example on the table of the 2 letters on the back page, peruse, for example, and all those words that are loved by lawyers come out, and they tend to be French words, French-sourced words. And Germanic words tend to be replacing them. Number 6, avoid sexist or ambiguous language. We're all getting better at this. When I had to write the report on North Korea for the Human Rights Council of the United Nations, I got drafts from the Secretariat and they were very, very good. These are really brilliant, dedicated, hard-working people. But often they're writing in a second language. Their first language isn't English. And so my job was to clarify and make sure I was happy with the text and with what was being reported. But my job was to make it clearer, and that involved putting words in that were clearer and taking words out that were judgmental or sexist. I had a terrible battle with one of the Secretariat about a particular word, and I'm going to have an informal vote on this. The word related to fishermen. There was a practice of North Korea of sending their boats near the Japanese border and seizing Japanese fishermen or South Korean fishermen and taking them back to North Korea and using them, basically. Very cruel. And I wrote fishermen. One of the members of our staff, who I would say was an Australian, she said, fisherman is not a correct word. You must use fisher. And I said, fisher? I know I will make you fishers of men. And I sang that myself many times when I was a boy, but it's not, I said, part of the ordinary English language. And she was most upset with me, and she sort of wrote me off as a dinosaur. Hands up those who think fisher is a word. Please don't feel embarrassed if you think you should use the word fisher is a word that either is or is emerging into the English language. Hands up those who think it's not. Yeah. Well, that's in support of my thing. What we did in the end, there's always a compromise. There's always a compromise. And so what I did in each chapter where this was referred to, I used the word fisherman, the first instance, and then put brackets, single inverted commas, fisher, close single inverted commas, close brackets, and thereafter fisher was used. So all people were happy. But her lesson was absolutely right. You know, there are words that we can use that are sexist, and we've got to try and get out of that, and especially in legal language. Number 7 is to try to avoid ambiguous expressions. Now, the biggest ambiguous expression in the history of Australia is in section 92 of the Constitution, which says trade, commerce and intercourse between the states shall be absolutely free. And the question was, did that stop marketing organisation and control of the production of milk in order that it was done in a rational way and so on, a matter not unimportant in Tasmania, or was that an impediment to the absolutely free trade, commerce and intercourse? So the more you can avoid things like that, Justice Dickson, whom I've just told you wrote the sentence with 498 words without a full stop, he said that when I die at my state funeral, I'll be carried down and the words absolutely free will be on my breast as I'm carried to my maker. Number 8 is ditch potboilers such as hereinafter, whereas, requisite, and all those other expressions that are just generally packing and are not really necessary given the context. And the letter on the back of the program is a good illustration of how you can say things more directly, more briefly, in clearer language, and there are many, many examples of that. Number 9 is layout. Now, this is where I was the friend of every student in Australian law schools. Layout, headings, subheadings, indent. I was the Daily Telegraph of the High Court of Australia because it has sales which are much higher than the Australian or the Sydney Morning Herald or the Age, because it's got white space and it can be seen, and you can see the drift of the whole thing by the design. So layout is very important. Headings, graphs. They were shocked when I used a graph in a case called Forge which is in 228 Commonwealth Law Reports, and it related to the use by the Government of New South Wales of barristers and ex-judges as acting judges. And I wanted to establish that this had gone beyond an occasional, totally exceptional, and that basically governments were not appointing judges and they were using part-time people who went back to legal practice and therefore they didn't have the tenure that was important for the independence of the judiciary. And the best way to do that was not in long-winded words, it was by showing the graphs of what was happening in other states and what was happening in New South Wales. And the graphs, I reproduced them in the Commonwealth Law Reports. People were shocked. I think the editor, the then editor of the Commonwealth Law Reports, thought this was a scandal that I had done that. But it made the point very vividly. It was like a photograph. You could see it, and you can look at it in 228 Commonwealth Law Reports, one at page 97. And the last one is keep in mind where your expression is going to come to people of a different language or culture, that may need some modifications. Modifications in terms of the words that are used. Mr. Keating, whom I'll be with tomorrow night because we're both celebrating the centenary of Sir Lennox Hewitt. He's reached 100 years. He was the chairman of Qantas and a long-time public servant of the Commonwealth, and he's celebrating 100 years, and he's still sharp as a tack, and he'd agree with everything I'm telling you here this morning. As would Mr. Keating, who he had all of these skills, but he added in a few sharp words as well, but we won't go there. Mr. Keating used the word recalcitrant. Now, apparently the word recalcitrant in the Malay language is a terribly insulting language, and when he called the Malays and Dr. Mahathir recalcitrant, that almost led to a break of our diplomatic relations. So you've got to be careful when you're dealing with a different culture, a different language, that the word doesn't have a different meaning in another language. And similarly with non-verbal communication, many of you will know that as part of Aboriginal culture, at least in many of the Aboriginal communities, you don't look a person in the eye. It's a discourtesy to do that, and you tend to look away, especially in a stressful situation. Now, some people don't know that, and they think because Anglos tend to say somebody won't look me in the eye, I don't believe them. Whereas apply that rule to the Aboriginal in non-verbal communication would be, and maybe in other cultures, would be a very unfair thing. And judges who say to interpreters, and I've seen it happen when I was a young barrister, just interpret the words. Why can't you just interpret the word? But the problem is that the word may be a metaphor. Take honeymoon. If you're translating into the Serbian language and you used the literal interpretation of honeymoon, a moon that was made of honey, then that would really not communicate the idea. You've got to be able to translate the metaphor or find the word in Serbian that is going to be equivalent to a honeymoon. But you've got to be aware that just interpret the words is sometimes not going to work. Okay, well, there are the 10 commandments, and even if, and I understand at the University of Tasmania students are taught plain, and that's a good thing. Most law schools don't teach plain. But if you just taught people these 10 things, and they had a checklist and they had to check their prose to make sure that they were ticking all the boxes, especially full stops, then our legal writing would be better, and that would be good for us. It would be good for citizens and clients, and it would be especially good for those who have disabilities in understanding and who may be on the receiving end of quite severe process because they've never understood or they've been intimidated by the long expression about the pips and the pulp and all the other things that are put into legal text.
Thank you, Professor Kirby. We have time for a few questions, so I'll just invite the panel members to come up and join us on the platform here. And we do have a microphone over here. Please wait for it so that we can make sure your question is recorded. There are two, so we'll be very quick. Yeah.
And is this one working? Oh, okay. And I'd just like to ask you to introduce yourselves as well before you ask your question. Would someone like to begin? Silence. Yes. Have a down here on table 2.
I've always presumed that if somebody can't explain something using plain language, it's because they don't actually understand it themselves. And so there's a sort of, if you don't understand it, you're going to use a lot of words to say it because you're trying to describe for yourself what's going on. And so you're not clear in your own mind, because you can often express something very clearly when you know what you want to say. You know what I mean? Does that make sense? That wasn't very clear.
This is really an application in this case of Oscar Wilde's statement. I'm sorry I didn't write you a long letter. Sorry I've written you this long letter. I just didn't have the time to write you a short letter. You know, in my judicial reasons, sometimes I couldn't understand what my colleagues were getting at, and I therefore had to explain things to myself. No judge on the High Court can be an expert in every area of the law that comes to the court. You get cases on the Customs Act, cases on the law of intellectual property, cases in the common law of mischief, and you can't be an expert in all. And I thought sometimes my colleagues, who were an expert in a lot of things, and many more than I, sort of made assumptions about what the law was, and therefore it's not only a matter of not writing lengthily, it's a matter of explaining things, and I had to explain them to myself in order to ensure that I was properly understanding the law and applying the law correctly in the case according to my understanding and values. So I think it's not just length, it's also clarity in explaining things. But it is true that you can waffle on and say an awful lot, but not get to the guts, as the Germans would say.
Would either of you like to make a comment about that? No? Do we have another question?
Justice Blow, Chief Justice Blow, is a very clear would like to say...
Well, if I've been conscripted, I'll ask the question, and it's thanks, Michael. It's akin to the previous question, but in summing up to a jury, a trial judge should generally bear in mind that if the jury system is working as intended, half of the jurors will be of below average intelligence. And what we have to explain is often something that's been laid down by the High Court or by a court of appeal somewhere, and not necessarily what we would have liked the law to be. One colleague of mine in Victoria said after a particular trial that the jury must have liked his summing up in relation to self-defence, his direction on self-defence, a great deal, because they asked him to repeat it twice. And it occurs to me that in Kilby's case, which we no longer have, the High Court said that when a woman complains that she's just been raped, evidence of that is not evidence of the truth of the fact asserted, but is relevant because it's corroborative of her credibility, something that I'm glad I never had to explain to a jury. How can one explain to a jury something as obscure as that?
And as well as that, there is the issue not just of lower than average intelligence, which the jury is the jury of our community and of citizens, and therefore it's going to have really geniuses and people of lower intelligence. But it's also generational. And there has been research on speaking to the jury, and in fact I wrote a brilliant article on the problem of speaking to the 21st century jury, which is in the Australian Bar Review, and it's about the fact that younger people, much less than older people, will not sit there for hours concentrating. You know, I see them on the train in Sydney at 5 a.m. in the morning when I'm going to work in Sydney. Everybody's looking at a mobile phone, and concentration is stimulated by messages. They just love to get these messages, and they're texting and playing games and everything's going on. And the idea of sitting down to an authority figure for hours talking on and on about things. And there's also the ruling of the High Court, which is not the same as the law in Canada. A question that juries often come back and ask is, what does that we've got to be satisfied beyond reasonable doubt mean? What does that mean? Does that mean we can have a bit of a doubt, but it's got to be a reasonable doubt, or what does it mean? And the High Court of Australia has said judges can't explain that to juries. They've got to tell them, this is a well-known expression, it's been used by juries for centuries, and you've just got to apply your common sense and apply what it means and come to the correct decision. That's not the law in Canada, but it's a very strong law in Australia. And if a judge trying to be helpful tries to explain what beyond reasonable doubt means, that will almost certainly lead to the case being retried. So there are some funny rules in this game, but that's a question of law reform. We are concentrating on legal expression. That's a big enough problem for us.
We have a question up here.
My name's Katrina McLaughlin. I'm currently with the Department of Health and Human Services within the Tasmanian State Service. I've worked in a number of different industries, and I did start out in the financial services industry, who did do a big push on plain language in the mid-2000s, and I'm all sure as individuals, if you are invested in anything like managed funds, you can see how unsuccessful they have been in that push. But I find it interesting now being involved in healthcare and this large issue of health literacy that's a big push at the moment, is that we are actually expecting our clinicians to provide literature for our patients. And I don't necessarily believe, particularly from a written perspective, that clinicians are best placed or have the skills to do that. In the legal profession, do you believe the lawyers have the necessary skills to create the written literature necessary for Joe public? Because certainly for our clinicians, that's not necessarily the case.
Perhaps you can.
Well, I share the same view in relation to clinicians, on the basis that at the board we often get medical evidence and healthcare professional reports, which are not always easy to interpret, and even our members of the board and legal members of the board aren't always clear exactly what the report is actually saying, and that requires us to seek further clarification. I think with lawyers addressing this matter, I think it's something that doesn't come naturally for many people. I think it is something that we have to learn, and we have to continue to attempt to train our minds in simplifying and using plain English. I see that regularly in my work, sitting on majority of hearings of the board, where there are days that I just get blank looks and I'm thinking, I'm not doing a particularly great job here in really simplifying our processes and what the requirements of our legislation is. And I don't think it's always particularly straightforward to do that either. So I think it's something that's a work in progress for many of us. I think with the right mindset of seeing how important it is, we can only continue to endeavour to do our best around this area.
I think we have time for one more question. Oh, sorry, Hamish. Please go ahead. Okay. Up the.
There was a point in Hamish's contribution about speaking clearly and a little bit more slowly, so that people can absorb messages that are important to them. After all, the sort of things that a lawyer is going to be talking about with a client is going, and especially somebody who hasn't had a lot of experience or education, and that can be helped by just telling them this is important and speaking less in a rushed way. And it all comes down to respect for a client. You know, sometimes lawyers are themselves quite stressed, as has been mentioned, and especially if it's a court case or a tribunal case, there's a lot of stress in the air, and it's not good for people and not good for communication. And you've just got to take a deep breath and do what Hamish said. You've got to talk more slowly, and you've got to tell them that this is important, that they concentrate and understand this, and otherwise they'll be back tomorrow. I thought that was a very good bit of practical advice on what can be done. But I think it's terrific that the University of Tasmania Law School is actually teaching this, because there's so much hostility. I was really shocked at how many of my colleagues laughed at this issue, and it's not a laughing matter. We've heard cases this morning in the disability area, but it's also people in our country. It's a multicultural country with lots of people. My partner is from the Netherlands, and you know, they're very similar to us, but they have nuances of difference. And we just say, well, they've all got to learn the English language, and they're here, and they're lucky to be here. And it's a matter of being respectful to other human beings. And if you're a professional person, that is your privilege and obligation.
Final question up the back there.
I'm afraid it's not really even a question. My name's Anne Hughes, and I'm just wanting to offer some words of consolation. The panellists have thrown out some challenges to us. There is help available. There's a whole discipline of editing. I'm the president of the Society of Editors, and there's a number of our members and colleagues here that you don't have to learn how to do it all by yourself. You can have partners in presenting good, clear language. You can engage an editor to read your work, to help you write it. I'm sure all of the panellists will have had the opportunity to make use of a good editor. We're around. Check our website.
Thank you. And I think that in 2016 we're working not just with the law faculty but also with the health faculty at UTAS, with some other areas where people are training students. I think we can all understand that it's better if we start with this from the beginning, because once we spend a long time in our careers, whether it's in the law or in the bureaucracy perfecting complex language, it's quite difficult to unpick that, and that's when we need the editors, and we can always get help. And a lot of the organisations we're working with are working on building the skills of their people to write more clearly, but they're also identifying that we need some expertise in that particular role as well. So I'd like to thank our panellists very, very sincerely for the contributions that they've made today, and for all of you for your engagement. I hope it gives you something to think about. 2610 is about action. We are here to help in whatever way it's appropriate. So we do have free plain English workshops for individuals or for organisations, and we can link you up with all sorts of people who can give guidance, and we can develop tools that will be useful in your particular area. So it's a flexible program. We would love your engagement. Please take the brochure that's on the table and think about getting involved if you haven't already. I'd like to thank Brendan Gogarty and the students from the Faculty of Law and Amal Cutler from the Law Society, and the 2610 team in Link Tasmania, who worked very hard to get this event organised. And again, a very warm thanks to our 3 panellists for being here today. Thank you very much.